Okay, this video covers Chapter 4, which is Intellectual and Intangible Property. And these slides are based off the textbook. First of all, let's cover some of the objectives of what we want to do in this chapter. First, we want to understand what the term intellectual property means. It has a very different meaning than tangible property. Things like a car, a computer. These are tangible, things we can hold and understand very easily that they are property. We also want to understand the concept of intangible property that has developed during the computer age. And we'll see some examples of that. So the U.S. Constitution actually recognizes the concept of intellectual property. And so you can see a quote here. You can read it for yourselves, but I want to just identify that you can see that authors and or inventors are provided exclusive right to their discovery of whatever they have written. And the reason for this is that the framers of the Constitution thought that inventors, authors, composers, these were things that we needed to improve the quality of life. So the ultimate goal was to improve the quality of life for all. And they thought that these activities were more likely to occur if people could make a living doing so. So for example, if somebody wrote a song or wrote some music, some lyrics to a song, they should be given the right to make money off that creation. And the framers of the Constitution felt that if somebody took the time and effort and the creativity to produce that song, and we didn't want to allow other people to just copy the song and for them to sell it, we would develop some laws to protect them. So the idea was that if people were more likely to make a living, they were more likely to do these activities with the long-range benefit of everyone's life being improved. Intellectual property, we are talking about products of creativity, so writing, dancing, music, etc. Invention seems to be a bit different. Invention seems to be when you're developing devices or products, things that you can generally hold. So a better mousetrap, a better cable connector, whatever the invention is. The difference you might think is nobody goes and watches for pleasure a better mousetrap. However, people would go to a concert to hear music. They view that as creativity. Again, tangible property, we're talking about things like a house or a computer. So the focus of this chapter is on intellectual property that is most affected by computing. And we're going to look at new types of intangible property that have arisen due to computing in the software that runs, say, the internet. So term piracy is essentially the illegal copying of copyrighted materials. Now here is a term, copyright, that we haven't actually introduced. You probably have heard of it. But we haven't defined it formally, and we will do so in this chapter a little bit later. And there seems to be a more significant difference between piracy and theft. There's a moral significant difference between copying intangible property and stealing physical objects. And this might be described by typical behavior that you see. So when people think about stealing a car or a computer, almost everyone views that as wrong and something you shouldn't do. However, when you talk about maybe copying pages from a textbook or swapping a song or taking a copy of a video, a lot of people don't think that is wrong, or they view it as less wrong because the frequency seems to be much larger. People tend to make copies of an intangible property much more frequently than people who are stealing physical objects. So we'll start off with the case, and this case is one that we're talking about, was in 2005, so over 10 years ago, easily. I don't know if you're aware of this, but here's the story. We're talking about Sony, the big company. One aspect of it is its music part. And in this case, that's involving the music part of Sony. So the idea was they started using a copyrighted protection scheme on its CDs. And so obviously what Sony wanted to do is their musicians. They want to package their music, put it on a CD, and give it to customers who have paid for it. And they didn't want those customers to be able to copy and be able to give it away for free. So they developed this copyright protection scheme to prevent customers from being able to do this. So the idea was when somebody put a CD in a regular CD player, it worked normally. Now, a regular CD player doesn't have the capability of redistributing or make copies of the CD. The problem was that Sony realized that most people wanted to listen to their CDs on their computers. And so what they did is they put some extra software on the computer they referred to as enhanced CD content. So what happened is when the CD was placed in the computer drive, there was automatically a rootkit that was installed. A rootkit did what it allowed unauthorized users to get access to the computer at higher level functions. And as you remember, we talked a couple chapters ago about having root access to your computer. Essentially, those are root access, and anything can be done to your computer with root access. They can look at files, they can do all sorts of things, and generally the administrator has root access. So when this CD was first put in, users were asked if they wanted to install this enhanced content, and if they agreed, the software did a number of things. It used the rootkit to get administrative access to the computer, even if the person playing the CD did not have administrative privileges to the computer. So for example, let's say my home. I have a computer with several accounts, and let's say my son would put in one of these CDs. My son does not have administrative privileges to my computers, but nonetheless it would install the software even without having this access. It would modify the operating system to place limits on how the CD's content could be copied a certain number of times. And it prevented the CD from being used on other unimproved music playing devices. So there was a piece of software that was put onto the computer, and further it masked its presence by using cloaking. And so the software they put on there, they tried to hide the software. The overall goal that Sony was trying to achieve was preventing people from converting CDs into MP3 music files and posting them on the internet. So Sony's goal, which is a reasonable one, was to protect their content. Now, other companies took a different approach. Some companies made CDs that could not be played in a computer at all. Now, Sony believed that they could be more marketable if their CDs played on computers, so that's why they did this. And so in order to do that, they opted for this rootkit notion. Other companies just threw up their hands and said, they didn't use it or any anti-piracy technology. Sony was in a middle ground on this with their approach. So a couple of other things. Normally a rootkit is to be avoided. A lot of malicious software takes form of a rootkit. If some malicious individual is able to get software of a rootkit running on your computer, essentially they have access to a lot of capabilities that can make you and your computer very vulnerable to inappropriate activities. So in general, rootkits are bad. There were companies, and one company in particular, Symantec, I'm sure you've heard of them, they're the virus people, that did not detect the rootkit even though they knew it was there. What Symantec said was that this rootkit was designed to hide a legitimate application. And so even though it was a rootkit, Symantec, this antivirus company, said it was legitimate. Now, there was a computer expert that wrote for Wired magazine, and he said, the only thing that makes this rootkit legitimate is that a multinational corporation put it on your computer, and it's not a criminal activity. The writer Bruce is being pretty critical of Symantec for not allowing their software to find this rootkit so that it could be removed. Bruce felt that the rootkit should be detectable no matter where it came from. So here are a few questions that will be dealt with on the online session for this chapter. Some of the things you should prepare for this online session is, first of all, understand the concept of the Sony anti-piracy and the rootkit case that we just talked about. And then here are some questions that you should be prepared to discuss that span the next several slides. Do you agree with security expert Bruce Shiner opinion? Should it be illegal for someone to convert the CDs they purchase into MP3 files, then use them in their personal music players? Some other questions that will be covered in this online session are, should the antivirus software distinguish between rootkits from major corporations and rootkits from criminals? Would it be fair to allow major corporations and deny rootkits from criminals? Would it be ethical for someone to remove the rootkit on your computer without Sony's permission? And lastly, would it be unethical to break the DRM lock on a Kindle book? The DRM is the Digital Rights Management, so that's what it stands for. So for example, I own a number of Kindle books and they run on Kindle devices, but they also run on readers on my iPad, but I don't have the option to read them in Notepad, as an example. So the text of these books has to be read in these readers. So make sure you're prepared to discuss those questions in our online session. So here's another case. This is another case involving a virtual investment fraud. Investment fraud schemes are common in MMO games such as Second Life or EVE Online. Games almost always have virtual currency, and players are often looking for ways to earn a quick virtual buck. So in 2006, Callie started an EVE Online intergalactic bank. She took deposits and agreed to pay interest on these deposits. In actuality, Callie was pocketing most of the virtual money. Callie reportedly walked away with 790 billion ISK, which is the currency of the game. Also related and important in this discussion is that there are websites that allow players to convert ISK virtual currency into real US dollars. And so this currency can eventually be converted into real money. And at the end, when Callie's bank failed, the worth was $170,000 of US dollars. So in the end, Callie admitted it was a scam, but she wasn't punished. The reasons she was not punished have to go along these lines, in that the game itself is about piracy and commerce. So intrinsic in the game was this concept of piracy, maybe cheating, convincing people to do things that they shouldn't, and that was all part of the game. So the company behind EVE Online decided that Callie did what was within the rules of the game. So the point here is that we all understand that creating fake investments is wrong in real life, but appears to be perfectly fine within the EVE Online game or other similar games like EVE. So in real life, with real investments, there are government agencies that prosecute this type of fraud. On the other hand, it is acceptable within the EVE Online game. I'd like for you to be prepared to address these questions during our online session. I'd like to address these questions in our online session, so be prepared to participate in this dialogue. I'd like you to defend or refute the claim, fraud is fraud, regardless of whether or not it occurs in a virtual world. Defend or refute the claim, stealing something that can easily be converted into real currency is real fraud. And finally, should the following be subject to a personal income tax? ISK earned in EVE Online, for example. As we found out, she walked away with $170,000. Should that be taxable? So in a letter that Jefferson wrote in 1813, he pointed out the difficulty of owning one's ideas. So I'd like you to read this passage. We'll just read it together. If nature has made any one thing less susceptible than all others of exclusive property, it is the action of thinking power called an idea, which an individual may exclusively possess as long as he keeps it to himself. But the moment it is divulged, it forces itself into the possession of everyone, and the receiver cannot dispose himself of it. So for example, an idea is not considered a tangible thing. If somebody gives you a book that you don't own, you can get rid of that book. You can give it back. But you can't really do this with an idea. Once it's out there, it's out there. So the focus of Chapter 4 is about intellectual property law, and it is very complicated. The textbook and these videos are meant to give you an overview at the level that computing professionals ought to be aware of. We're not going to be patent attorneys or anything, so you just need to have a fundamental understanding of what this means. We're going to talk about the key protections of intellectual property protections that directly affect computing. And there are 3 of them that we're going to focus on, which is copyright, patent, and trademark. I'm going to guess that you all have probably heard about all of these before, but may not know when one is applicable or not. So we're going to be talking about just that in this section. When looking at intellectual property law in the U.S., you have to consider some fundamental questions first. What can be protected? Patents protect inventions, not artwork. What rights are reserved for the creator of the work? So for example, it is not okay to use a photograph without the photographer's permission. What rights are reserved for the public? With improper references and citing, one can use short quotes from a book for scholarly work. How does one obtain the protection for a work? And how long does it last? Those are some questions we're going to cover. So, copyright protects creative works in art, music, and writing, and it protects original works of authorship. It must be tangible medium of expression. In the areas of literature, music, drama, pantomime, graphic art, sculpture, motion pictures, sound recordings, and architecture, those things can be copyright. It does not protect ideas, facts, or common knowledge, and it does not protect creative works until they appear in a tangible fixed form. So, for example, a dance choreography wouldn't be considered copyrightable until there was a video of that routine. Getting something copyrighted protects the author and the work that he or she has created as soon as it takes on that tangible form. You can tell when a piece is copyright because it will always be listed on the piece somewhere. So for example, our textbook lists the following. It has a copyright symbol. It says 2013, Cengage Learning, and goes on to say all rights reserved and all of this mumbo jumbo. But that is the form that you can tell if a piece is copyrighted or not. Now, these words are often helpful if you plan to enforce your copyright, but because it establishes a date that the work was created and it establishes an owner. The length of a copyright is the lifetime of the author plus 70 years. So in general, let's say that we have somebody who writes a book. They will have their entire lifetime to make money off of it, and then 70 years after, which could go to their heirs. Any money they would make could go to their heirs. So there are 4 main components and rights in a copyrighted material, and they are you have the ability as the owner to reproduce a copyrighted work. You can prepare derivative works based upon the copyrighted work, and you can distribute copies of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. And number 4, perform or display the copyrighted work publicly. Only the author can use the work in these ways. An author can authorize others to exercise these rights. And 2 main rights reserved for the public that we're going to go over here is first use and doctrine of first sale. So the idea of fair use is that somebody can use parts of a copyrighted work in certain situations. So for example, in a criticism, somebody can, from a movie, like a movie critic, can pull out portions of the movie and criticize parts of the dialogue. In teaching, this is a big one, of course, teaching, as long as it is reasonable, can take passages and reuse them and transmit them to their students. And certainly computers, as you know, make using copyrighted materials really easy. For you personally, before you use copyrighted content, you should consider whether or not it is fair use. So there are 4 factors that should be used in determining fair use. Number 1, the purpose and character of the use. Is it for commercial, nonprofit, educational, etc.? So for example, if I were using an image in a report for school, that might be considered more fair use than if I were using that image in a commercial product that I was going to make money off of. Number 2 is the nature of the work. Is it published versus unpublished? So for example, if the work that I'm copying has already been published, say I'm pulling up excerpts from J.K. Rowling's Harry Potter stuff, that is probably more culpable than if I were pulling excerpts from some unpublished article deep in the internet. And then you have to consider fiction versus nonfiction. Generally, it is easier for people to violate fiction than it is nonfiction. So for example, if I use Harry Potter again as an example, if I were to pull excerpts from the Harry Potter books with the different imagery that she used, I'm probably more likely to be outside of fair use. However, if I were to pull out excerpts from a factual recounting of something, that would be more in line with what is considered fair use. Number 3 is how much material you pull out is also relevant. So if I were talking about a book that's 600 pages and pull out 2 sentences as a part of a critique, that would probably be considered fair use. However, if I took out several important pages, then that would not be considered fair use. And finally, number 4 is the effect of the use upon the potential market of copyrighted work. Have I affected the owner's ability to make money off of this? Consider that when you're doing this. So here's an example, and I'd like you to think about this for the online session. Let's suppose that we have a college course on computer ethics. That's probably not too hard to imagine. And we talked about the Wired article that was critical of semantic. So in this case, let's suppose the instructor gave copies of the article instead of directing students to the Wired website. Do you think that would be fair use for the instructor to do? So I'd like you to think about that and provide some input as to why you feel that way and to support your stance for our online discussion. Okay, fair use example number 2. So here's another example that builds on the previous example. We're talking about an instructor for computer ethics course. So the instructor borrows from an ethics textbook. They make copy of one of the chapters and then post it to a public website. Is that fair use? Again, provide an answer and evidence that will support your stance. And then also situation 2, which is slightly different, is instead of posting it to a public website, the instructor posts it to a website that is password protected. Is that fair use? Is this more likely to be a fair use? So think about that and prepare your answers. Okay, so doctrine of first sale. Remember the public reserved had some rights in this. There was 2 of them. The public had fair use, and the second thing was doctrine of first sale. So authors are not entitled to a second royalty. So for example, if I buy 1 copy of a new book, the author gets royalties on that. But if I sell the book, the used book, to someone, the author does not get a second royalty. In the adoption of this first sale that the owner of a particular copy buys, I can do anything I want with the book. This rule was created in 1908 and made sense then. However, it's becoming more difficult when physical books are giving way to e-readers and CDs to MP3 files and things of that nature. It may not make as much sense in our current computer age. So you'll see that the concept of fair use and first sale is eroding due to our current computing environment. We're talking about digital rights management, DRM. We've already talked about that. So essentially, what these are technologies to ensure that the content is viewed or heard only by the purchaser. Generally speaking, the copyrighted material is encrypted on the disk or the media. And what encryption means is it means that you need a numerical key to unlock it. Otherwise, it's all garbage. So hackers can and they do take encrypted material and decrypt the material and produce unencrypted versions. The Digital Millennium Copyright Act, DMCA, of 1998 law says that no person shall circumvent these technological measures. So if I receive and buy a book that happens to be encrypted, I should not try to decrypt this material. Okay, so here is one of the thinking it throughs and how it might relate to you. So the idea here is that students prefer used copies over new textbooks. So for example, if a new book costs $100 and a used copy costs $99, I would probably buy a new book, as I'm really only going to be saving like 1%. If a used book saved only 1%, how big of a price difference do you need before you would buy a used book? So just out of curiosity, I'd like to know what your thoughts are on that. You don't particularly need to have evidence to support that because it's more of a personal decision. So we have the term plagiarism and the other term copyright violation. And these two things are different. Plagiarism is when somebody copies materials and passes it off as their own. A copyright violation is when you use some copyrighted work without the permission of the author. So the question that I want to discuss during our online session are these following questions here. Can you have plagiarism without copyright violation? So I'd like for you to think about that, provide evidence that would support your stance, and then answer the second one, can you have copyright violation without plagiarism? Which is the flip side of the first coin. So I've included a link to an article that you might find entertaining around this topic, and I'd like for you to look at that and enjoy. Okay, so there's a case here that occurred in 1994. The year is actually important here in this case. So a guy named David Lamacchia was charged with criminal copyright infringement. What David did is he posted copies of copyrighted material, let's say like software like Excel or something like that. He allowed people to download them for free. And at that time, the law said that copyright infringement was criminal only if the infringer acted for the purpose of commercial advantage or for private financial gain. Well, certainly in this case, since he was giving them away free, that wouldn't be a violation. So the case basically was thrown out. A short time after that, in 1997, Congress passed the No Electronic Theft Act. It simply said to change the definition of the term financial gain to include receiving copyrighted works for free. So it kind of fixed that loophole, so to speak. So another thinking it through. The NET, which is the No Electronic Theft Act, made it a criminal offense to share copyrighted works with a total value of more than $1,000 with any 180-day period. So now we have some limits. So for example, a casual person who is sharing but is not at a criminal level, which is listed above, would not be committing a criminal offense. The penalties are pretty stiff if you do violate these limits. You should see these every time you watch a movie. There's always big fines posted if you copyright or copy a movie. So imagine that you routinely swap music or movies with friends. What I would like for you to do is to think about these last few items for our online session. Are you likely to cross $1,000 with any 180-day period threshold? In other words, are people who are acting morally likely to accidentally commit the crime of sharing too much? So think about that. Okay, so here's a story about a company you may have heard of, because it's been a while, and but over a decade or more ago. So a company named Napster that came into the news in a big way during the music piracy, because when music piracy was a really big deal. So what Napster was what was referred to as a peer-to-peer service. It allowed users to search for files to download. Napster did not download, upload, or store copyrighted materials. Rather, the software allowed users to swap copyrighted files with each other. What I would like for you to be prepared to discuss during our online session is, was Napster's business model not morally permissible? And how is this different from search engines like Google? So the courts basically in this case said Napster committed contributory infringement, which is infringement committed by another person, would not have happened without the help of this company. And also vicarious infringement, which was infringement that occurs in an area under your supervision, and when you should have been policing and preventing such acts. So Napster knew what its users were doing, and Napster allowed people to do so because they made money off of it. So the courts did, eventually shut down Napster. So again, think about these questions, and I'd like for you to have some supportive verbiage to support your stance. Okay, so BitTorrent is a technology that is used by movie pirates and software to share files. It is also used by legitimate software companies because they use them to deliver one large file to millions of users. So as an example, let's say that Microsoft or some company wants to distribute their next version of an operating system or application. Because these files are so large, pieces of it are uploaded so that thousands of users can download them. And this whole process is really called seeding the file. Users pass their piece out to the other users who are also looking for it. And BitTorrent is beneficial for distributing large software updates like this. So we have a copyright limitations that we ought to examine. And you can see that over the years, copyrights, for example, the original Copyright Act of 1790 allowed a maximum of 14 years. You've got an original 14 years to make money off the work. That's basically what it was back then. You can renew it for another 14 if the author was still alive. And so the maximum was 28 years. And you can see that these maximums have grown throughout time. The latest down here is 130. That's, again, we talked about this a moment ago. That's the author's lifetime plus 70 years. Now, these long copyright terms, one person may say, why should they expire at all? For example, if I own a piece of land, when I die, I can will that to my kids, and they can will that to their kids, and so on. So if I wrote a book, I could will those rights to my children. That's one argument. There are a couple problems with the long copyrights in that, first of all, copyrights can be sold or traded, and it's hard to know who owns the copyrights to all the works. So there's a concept of what is called an orphan work. It is a copyright work that is still within its copyright terms, but there's no longer a copyright owner. So for example, let's use a museum that has some photographs of World War II, but they don't know who the photographer is. These photos were likely taken around the 1940s, and since we don't know who the copyright owner is, we have to wait for 130 years from 1940 before we can safely display those photos again. Some people are critical of the copyright length. Some people want it to be shorter, and some don't want them to exist at all. This video discusses that, and I think you might find it entertaining to watch as well. So just a few questions to think about, and these are questions I want you to think about and answer during our online session this week. Should it be legal to print a t-shirt with the Mona Lisa on it without paying a royalty? Should it be legal to print a t-shirt with Disney's Phineas and Ferb on it without paying a royalty? Should it be legal to trademark a color? So now we're going to talk about patent law, which is different than copyright. Remember that copyright pertains to creative works. Patents pertain to inventions. We're talking about a process, a device, and the like. Anything to improve the current state of affairs is an invention. So the U.S. Patent and Trademark Office issued 2 criteria, novelty and non-obviousness. Novelty, which means an invention is novel only if it has not previously been invented by someone else. Non-obviousness, which is a solution to a problem that is obvious to another specialist in the appropriate field and cannot be patented. The term obvious is debatable. So court cases to invalidate patents focus on the challenging concept of is it obvious? Is this an obvious invention? The length of a patent is typically 20 years from the filing date, and others cannot make use, may not use or offer to sell or sell the inventions without the patent holder's permission. Trademark is a different type of protection. This is a legally registered work, phrase, symbol, or other item that identifies a particular product, service, or corporation. To register a trademark, you have to be using it, and your trademark cannot be confused with competing other products' trademark. So, for an example, and this is a true example, I have a son, I have 3 sons actually, and one goes to Jonathan Alder High School in Plain City, Ohio, and they have an A as a kind of a trademark, A that they use for Adler, their school name, and the University of Arizona filed a complaint against this little old high school in Plain City, Ohio, saying that their A was too identical to their trademark A that they use for their university, and therefore the high school that my son goes to had to come up with a new logo for the A that was not close enough. So it does happen. It even happens in the smallest places you wouldn't imagine. So trademarks last 10 years but can be renewed indefinitely. And the difference between a trademark versus a brand refers to the product's identity, where a trademark is one specific element of that identity. So here are some trademark examples. T-Mobile holds the color trademark magenta, where AT&T holds blue, and Sprint is yellow, and of course Verizon is red. So the special note here is that the trademark color for these companies are just, they're able to do this as it pertains to the wireless component of market of their company. So in other words, they don't own, T-Mobile doesn't own the color magenta that nobody else could ever use. That's not how it works. But another wireless company couldn't come along and use the trademark color magenta to sell their products. So if I were, in a business of creating a gardening tool and I wanted to use magenta, I could trademark that for gardening tools for my things as long as it wasn't done somewhere else. So you can look at some other examples here on this slide. TiVo holds a trademark for the 6 Pops. Motorola holds a trade on the chirp sound it made on the phones, and Coca-Cola holds a trademark on the bottles that they put their Cokes in. So trade dress involves something a bit more abstract. It involves the look and feel of a product or its packaging. So for example, when the Nintendo Wii was designed, it had a recognizable design and trade dress, and they got that protected. So the concepts of trade secrets have to do with companies being able to keep their algorithms secret. So as an example, most internet search companies keep their algorithms secret, which prevents competitors from stealing them. Now, one could patent their secrets, but the whole process of patenting would divulge the secrets and make them available to other competitors to take and try and improve on. So that's where the trade secrets came up with. Intellectual property laws were not needed to protect trade secrets. Virtual goods are obviously different from goods you would be able to buy in a store. And with the rise of the internet, there's a whole new set of things referred to as virtual goods. These are things that exist only in online systems. You can point out many websites allowing game players to trade their virtual currency for real currency. And remember the case of Callie in the EVE Online game and the Galactical Bank. Is there any real difference between them? I would like you to contemplate that, between virtual currency and real currency. Is it reasonable to spend real money on a virtual item? Here's some other examples of virtual goods. World of Warcraft players invest time to obtain weapons that exist only in this game. The ISK, which is a currency, is currency in a virtual currency, and again we saw that in the Callie case. So what about protecting virtual goods? You know, we protect our physical goods. This is not too far of a stretch to imagine. So the idea here is, let's consider protecting physical property. I have guitars. I'm a guitar player, and I keep my guitars in my house, and I protect them. People can't come in and just steal my guitars without having consequences. With virtual goods, there is almost no way to make a backup copy or transfer it to another system. Only the hosting company is capable of preventing the loss of a virtual good. In a dispute between a consumer and a hosting company, the consumer has very little recourse to get a virtual good back. So here's a case, Bragg versus Linden Lab. The story goes like this. The plaintiff had owned some virtual property. The defendants on the other side took away his virtual property and denied him access to the virtual world. So the question is, what type of obligations grow out of this type of relationship? Even though the property in the world exists in a virtual world, this dispute is really real. So in this case, Bragg's acquired a parcel of virtual land for $300, which he paid with real money back in 2006. And Linden said the land was purchased through an exploit. Bragg's argument was that this virtual property was worth, in real life, at that time, was worth between $4,000 and $6,000 in real U.S. dollars. When Bragg signed up for this service, he would have had to agree to the terms of service, which is a set of terms and conditions you must abide by in this virtual world. And every application, software, all of them have this terms of service. It's everywhere. So here's another example called Fairy's Hope. Oh, and by the way, Bragg's didn't get any money back, and he didn't get any ability to it didn't go in his favor. The company won because of those terms and service agreements. So here's another example called Fairy's Hope. Fairy's Hope poster is clearly based on a 2006 photograph of President Obama, which was taken by a freelance photographer, Manny Garcia. This example has a picture, and in this case it's Professor Brinkman. And there's a picture on the left side and then a posterized version as well on the right. And clearly this is a knockoff on the President Obama's picture. So there are three parties involved. Mr. Garcia, the Associated Press, and Mr. Farley. And Mr. Garcia is the one who took the original Obama picture, and he claims he never assigned the copyright to the Associated Press. And the Associated Press believed it held the copyright to the photograph, and also believed it should have been credited by Mr. Farley, and believed it should have received monetary compensation. Mr. Farley believed that his use of the photograph, regardless of who held the copyright, was a fair use, and hence not a copyright violation. So this next case is referred to as the Plays for Sure case. Essentially, Plays for Sure was some digital media standard created by Microsoft. And when you use this file for the first time, your device must contact a key server. And key servers provide the keys to authorized users. So in 2008, and oh, by the way, I would imagine without the key server, this would all be encrypted material that you couldn't access until you had the key to authorize it. So in 2008, Microsoft told its customers that it would be turning the key servers off in a couple of months. And after that date, it would not be possible to reauthorize a certain file that you'd already purchased. So people were upset and complained, and Microsoft reversed their decision to shut down in a couple of months and said, okay, we'll keep it open until 2011, which basically gave people more time to make other plans. So some people suggested that Microsoft should distribute an unlocker. This was a continuation of the same case, which would be a program that would permanently remove the encryption on these devices. So why is this not a decision that Microsoft can make on its own? I want you to think about that. That's a question to consider for our online session. I can think of all kinds of reasons, and I hope that you can too. So this next case is referred to as the DECSS case. Essentially, what these things are a program that removes the copy protection from DVDs. So remember the Digital Millennium Copyright Acts, which prohibits circumventing the digital rights management stuff on any copyrighted work. So it also prevents the trafficking of these devices. So what this says is if we had a DVD that had copyrighted protection on there, we can't use a DECSS program to unlock it. So Eric Corley went to prison for trafficking circumvention devices. And activists developed innovative ways to spread this DECSS and selling the code on t-shirts and paintings and songs. So in this case, should the internet activists also have gone to prison? Or were they protected by the First Amendment right of freedom of speech? If they were protected, why wasn't Corley? So contemplate that too. So DECSS was a very simple idea, perhaps too simple to count as a true DRM system. Should ease of circumventing be relevant here? So now we're going to talk about intellectual property protection as it pertains to software. Computer code is a creative work and is copyrightable. However, like phrases, very short snippets of code can't be copyrighted. So for example, phrases like attaboy, you wouldn't be able to get that copyrighted. The look and feel of a game as a whole can be copyrighted. And as an example, let's consider the Pac-Man case and Atari, the owner of Pac-Man. They sued North American Philips for violating the Pac-Man copyrights. And just since I'm a child of the Pac-Man days, I'm old enough, you guys won't even probably thought of, most of you. I went ahead and looked up this game and played it for a little bit, and it is extremely, very similar to the original Pac-Man game, so I understand the dispute. But trademark law, as you remember, is used to protect look and feel, not copyright. So what was interesting to see that this case involved copyright instead of trademark. And here's another example. Blue Nile is just an online jewelry store, and it sued Icecom, which was another jewelry store. But in this case, it sued over the trademark dress law instead, and they actually won. I don't believe that Atari won that last lawsuit against the other, because it was not suing over trademark. It was suing over copyright, which didn't seem to fit. That's the point here. Okay, so it's reasonable to patent a piece of software if it's a genuine invention. Not surprising, experts cannot agree which are genuine inventions and which makes this difficult. And others question whether or not you can even say a piece of software is an invention. These are just some of the arguments. So examples of this are Amazon. They patent their one-click shopping. So I don't know if you're familiar with that, but it's the ability to you buy things on Amazon or anywhere for that matter, but in this case we are talking about Amazon. Every time you would buy something, you'd have to go through and decide the shipping and the payment and all of that. And the one-click shopping is exactly that. You find something and you click it once, and it knows where you want to ship it. It knows your address and your payment and all of that, and it was a great thing. And so they were issued a patent for this. And Apple actually licensed that patent and is using it. So, I'd like you to think about these questions here. Is one-click shopping non-obvious? Remember, that was one of the criteria to determine if it was an invention. So would most developers of online shopping sites hit on the idea of a one-click shopping notion? I'd like you to think about that. And there's an argument the U.S. Patent Office is not competent because they regularly award software patents for non-inventions. So that's why this question is relevant here. Okay, patent algorithms. So controversy exists as to whether or not a patent should be used to protect an algorithm. So, for example, adding two numbers. Is that patentable? Another example would be Google search algorithm, and in particular, their PageRank is patented. And that is an algorithm that allows their search engine to put what they deem the highest hits on a search that you're going to want. That's an algorithm that they've developed. So PageRank might be viewed as a basic mathematical fact, but it was something that they developed. So equations are relatively simple and can be found on Wikipedia, but they were not simple to discover. So that's where this all came from. Many resources that are not owned by any one person is a concept referred to as Creative Commons. So fish in a public stream, grass on public land. These are things that are used jointly by everyone and would be normally found in what's called the Creative Commons. So free culture. Harvard Law professor Lawrence Lessig has made a few observations. Historically, most creative work has been, and these are the points he made here, Most creative work has been in the commons, and technology has pushed intellectual property owners into a corner. And owners feel they must hold on to their livelihoods. And current copyright law allows very little material to enter the commons. So Lessig and Hal Abelson and others came up with this. They're the founders of this Creative Commons. And it was designed to help people release their work into a place where they didn't necessarily weren't developing it or creating it for commercial purposes. So I'll just let you read through that slide. That's just more about the whole Creative Commons process. And if you don't know about Creative Commons, it is worth looking into, because as somebody who's a teacher like myself, and in IT, there's all kinds of pieces that are in the Creative Commons that people put out there for free use, or sometimes a fee. So multicultural issues that come up in this realm are things like region coding for video disc. DVDs are coded based on a geographical region, and they contain a digital signature. And for example, in the US, it's 1 for region 1. So DVD players sold in the US only play on region 1 disc players. Some of this is related to movie release dates. So let's consider the US. Let's take, say, a movie that's released in December, which as of this time I'm in December. So it's released in December in the theaters. Let's take the latest Star Wars movie. So in a couple months, they'll release the DVD here in the States. But in Japan, the movie won't get released in the theaters until probably June, and then in the following November for DVD sales. So Japan residents need to wait until June, because there's no way, well, actually there probably is through all of these BitTorrents and other file exchanging systems for there to get rogue copies, but to own a real copy, the way it's established, they're not going to be even available till months after we've had them. So something else that results from this is what is referred to as price discrimination. Usually richer people pay more and poorer people pay less. So in this case, like the Chinese version of the movie might cost $3, whereas in the US it might cost $20. So now here are some questions that I would like for you to contemplate for our online sessions, and that is, should region-based price discrimination be prohibited? Why do you think region-based price discrimination is legal? And which of the copyrights enable the copyright holder to charge different people different amounts of money? That's a fascinating question. I'll look forward to your thoughts on that. Okay, so we want to talk about Pirate Bay, which is a website. We have, if you recall, BitTorrent sites, and these are the sites that essentially allow searching for computers that hold parts of a file. If you recall, BitTorrent is a process where large files can be broken down into smaller pieces for the easy ability to download them. And index sites allow searching similar sites to Napster's for this same kind of concept. So the most popular index site is called the Pirate Bay, which is based in Sweden, and it allows users to search for torrents. It also allows its users to find other users with whom to swap file pieces with. And Pirate Bay was repeatedly shot down by the Swedish authorities, which didn't really stop them because they simply relocated to a new ISP. So in Sweden, there is actually a political party referred to as the Pirate Party, and they focus on three main issues, which is privacy protection, copyright reform, and reduction or elimination of patents and other private monopolies. So you can obviously see that these latter two certainly focus on intellectual property rights. The Parata Parteets, I can't say that very well, statement of principle says that the copyright will encourage the creation, development, and dissemination of culture. The thing that copyrights are abused today. They think that copyrights are abused today. So obviously this political party is against the current way of providing intellectual property holders protection. So how can one achieve protection without these mechanisms? Here's one famous example. L.J. Comrie was a compiler of mathematical tables. And at one time, for example, he created a bunch of books of algorithms. Obviously now we don't do that. We just punch our information into a calculator and a spreadsheet and get the information via the computer computation. But this was a while ago. So the author computed these tables of numbers. He was aware there were some errors in the book. Actually, it was hinted that maybe those errors were somewhat intentional to protect his works, because he knew where the errors were, and that way, if somebody were to steal it and they were the same errors, he would have some hope of defending that those were his, because he knew exactly where they were, and they were buried so deep that likely somebody else wouldn't even know it. So it was thought as a potential way to detect plagiarism, which takes us to another topic. Helen Hegman's first novel contained plagiarism passages, and she was a finalist for the best novel at a book fair, where she won an award worth $20,000. But it was later found out that some of her stuff was plagiarized, and she said she should have been more open about her sources, and she also defended herself as a representative of a different generation, one that freely mixes and matches from the flood of old and new media, and there's no such thing as originality anyway, just authenticity. So the argument is that if the new work created by mixing its original with authentic overall, then it does not matter if some sentences were taken from elsewhere. I think she ended up not getting, having any problems here. So some questions to think about here that come out of these last few slides. Assume Comrie did use errors to catch plagiarists. What would Kant have viewed Comrie's decision to leave known errors in his table? Would he view that as moral or immoral? So I want you to go all the way back to Kant's theory and contemplate that one. And then another question is, which do you find to be more acceptable? Which relates to this last case about the novel and the woman, Helen. To bar sentences without attribution when writing a novel for publication, or when writing an assignment for school. So two different context scenarios. I'd like you to compare and contrast which one you find would be more acceptable. Okay, we are finishing up this chapter, but before we do, we need to talk about the philosophical foundations of intangible property law. So which ethical theories support the legal protection of intellectual or virtual property? There are two different approaches we're going to consider: the consequentialist approach and the deontological approach. In the consequentialist argument, the Constitution gives creative rights to authors. Their argument implies that society needs authors and inventors. A monopoly is needed to encourage more people to create and invent. That's the whole consequentialist view. And the concept is not based on the rights of the authors justice, or caring. It is based on idea that these rules will increase happiness. So you see how we're doing that, right? There are a number of examples where this notion contradicts their argument. Authors of open source products, for example, willingly give up most of their intellectual property rights. Wikipedia is another good example. So I want you to really think about these two slides here. We present the consequentialist argument, and here's something that kind of challenges that through these other notions, which I think are very valid. So the intangible property, the deontological argument, so if you recall, this focuses on the rights and duties of individuals, not the consequences of actions. The deontological theories lead us to question the very foundation of the idea of property. Does a right to property exist at all? And if you recall from chapter 3, there were some disputes whether there is a natural right to property at all. So John Locke, this is a couple of centuries ago, said that a natural resource becomes ours if there's plenty for everyone, and we can transform it into something new through our own labor. The problem is, it does not address what happens when you don't when you don't have intellectual property due to a lack of competition, and does applying this theory of property to virtual property work? So I'd like for you to look at this slide, and it's a fictitious case. Imagine that you're playing an online game and you obtain a valuable virtual object that you don't want. You sell it through an online auction for $10,000. And after handling the item over to the purchaser, so this is a case about somebody who's doing this. You put a stop order on the payment, effectively stealing the item. So you pay for it, but then and you get it, and before the money's transferred, you stop it. Should the police treat this theft the same as a theft of a real $10,000 item, such as a car? And again, probably beating a dead horse here, but this is really how technology is impacting us, and our laws are not moving quick enough. So from an ethics standpoint, you really need to understand this. Okay, I guess that brings us to the end of this chapter, and there's several things I'd like for you to go back, make sure that you capitalize on and are prepared to discuss in our online session, and we'll talk to you then. Thanks.